Treasurer, would you do the honor, please?
Yes, I will.
The invitation.
Please stand. Dear Heavenly Father, as we gather here today to conduct the business of the Cherokee Nation, we ask that you give us guidance. We ask also that you keep your hand upon the people that within the tornadoes and the flood damages that's been in our country. So, Lord, we ask you to watch over our Cherokee people, watch over the people of the United States, watch over our troops overseas and those that are at home. And we ask all this in Christ's name. Amen.
Thank you, Mr. Treasurer.
Meredith Fraley. Here. Bill Englund.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Bozer.
Here.
Julia Coates.
Here.
Bradley Cobb.
All honey.
Joe Crittenden.
Here.
Jody Fishinghawk. Here. Janelle Fulbright. Here. Don Garvin. Chuck Hoskin Jr.
You have a video conference, can y'all see her? Yes. Can you see her?
Yes, we can, Chuck. Can you hear us?
Yeah, he's trying to.
Continue with roll call.
Chuck, can you hear us?
Yeah, I can hear that.
Okay.
Tina Glory Jordan. Present. Curtis Snell. Chris Zoe.
Here.
David Thornton. Kara Cowan Watts. Honey, we do have a quorum.
We have a quorum. Next order of business is approval of the April 28th regular session minutes.
So moved.
A motion and a second. Any discussion on the minutes? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Minutes stand approved as written. Next are reports. Ms. Wright.
Would it be possible, I understand that we have a couple of people that are here for confirmation on the board, that we possibly amend the agenda and allow them to be presented
Sure.
prior
You
to
make that
reports?
motion.
I'd make that in form of motion.
Moved in second. Any discussion on amending the agenda to allow the nominees to come forward first? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Now, you want those before reports, is that correct?
Yes.
All right, so under item 1 is a resolution confirming a nomination of James Amos. Mr. Amos here? Yes. You want to come forward with Mr. Sutherland?
Just wanted to introduce Mr. Amos and Mr. Yates, who are both up for consideration today for the Housing Authority Board. I just wanted to disclose one item for Mr. Amos. He did, when he visited with the chief a few weeks ago, he disclosed that he did have a rental property that was getting rental assistance through the Cherokee Nation's Rental Assistance Program. I asked the Attorney General's office to do an opinion on whether or not that was allowable. It was not. They gave him 3 options. One of those was to deed the property to someone other than himself. And he has done that, and he has complied with the Attorney General's opinion. And just wanted to disclose that and make sure there wasn't any question on that. But
Thank you.
I'll leave him with you all.
First of all, do we have a motion to confirm Mr. Amos?
Second.
Second. Okay, now discussion. Mr. Amos, would you like to say a few words before we quit? If anyone has any questions?
Not really, I guess. Just if you have any questions, I'll be glad to answer them.
We do have his resume in the book here, so does anyone have any questions of Mr. Amos? Okay, you did good. Oh,
Well,
yes,
thank
we
you.
do have one.
All right.
I just have our one standard question. You are Cherokee, is that correct?
Yes.
Okay, thank you. And you
All in favor
live
of-
within the 14 counties?
Yes.
All in favor of Mr. Amos's nomination, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. Thank you for being here today.
Thank you.
Next agenda, under new business is resolution confirming the nomination of J. Anthony Yates to the Housing Authority Board of Commissioners.
Make a motion to accept Mr. Yates.
I second that.
Motion and a second. Mr. Yates, good afternoon.
Thank you, Madam Speaker.
Thank you for being here. Would you like to say a few words?
just, I know the importance of the housing authority and that it increases a lot of the standard of living for a lot of people, and I'd be glad to help out in any way I could.
Ms. Fishinghawk?
Same questions this time. You live in the 14 counties in your Cherokee?
Yes, ma'am. Sequoia.
Okay, thank you.
In Sequoia County, from Mr. Thornton.
No, that's great.
Any other
I'm
questions?
surprised there's more than that.
We have a motion and a second. All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Thank you for being here today.
Thank you.
Just one cleanup item, neither one of these had sponsors.
I'm on here as a sponsor.
Put me on sponsor for the
Me and Shelley and Don, David and Don and myself. It was too late to be on the book.
So you all sponsored.
Yes. Count one.
Thank you, Madam Speaker. If there are no objections to the other co-sponsors on Mr. Amos, since he lives in my area, I would appreciate being added.
Can we add Ms. Calmont? Okay, any other questions, comments? Okay, now moving on down to reports, and we will limit the reports to 5 minutes and then 3 minutes per person on questions. Ms. Wright?
Good afternoon.
Good afternoon.
I submitted my report a little late. I thought it got in the packet, but I'm not sure, so did you get it? Okay. And there was one typo in there of saying December, because I edited through an old report, so that was for last month. I'll answer any questions you might have.
Questions or comments for Ms. Wright? Yes, Mrs. Thornton.
How many officers are assigned to C and B for CNE over there at the police?
Through our contract, we've got, sort of complicated, we've got 4 regular officers that are assigned, and we have 2 investigators, and then we have an investigator that we share, that they pay part of their salary and we pay part of their salary.
Thank you.
Any other questions? Thank you, Sharon.
All right, thanks.
Ms. Hammonds? You've been a busy lady, haven't you?
Thank you, Madam Speaker. Yes, I was sitting out of camera range, then I had to crawl over everyone to get up here. Pardon me. Good afternoon. I think you have our report. I wanted to add, of course, the latest news that's happened since we submitted our report, and we sent you a copy and had an informal discussion with some of you regarding the Eastern Oklahoma regional offices of the Bureau of Indian Affairs recent decision, May 24th, which allows the United Kituwa Band to take land into trust for a 76-acre tract. You have that decision, your attorney's had it, and he's prepared a very good memo and synopsis of it and our options. We've talked to our outside counsel. It will primarily be handled at the appellate level, of course, under my supervision by the Sonosky firm. Lloyd Miller and Arthur Lazarus, as many of you know, have done a lot of these sorts of issues for us. Arthur, I'm sorry to report, is retiring at the age of, 85 years young. I wish that I were as sharp and energetic as Arthur is now, but this may be his last project. So in that respect, we're fortunate about the timing of this because Arthur can still work on it. The next action that we need to take in this administrative matter is giving the notice of intent to appeal to the Interior Board of Indian Appeals, which is outlined in the next to the last paragraph. That's an administrative notice that the Sonosky firm's working on. We probably will have that ready in the next few days. Be glad to take any questions, answer them if I can about that or any other matter on the Rules Committee. Oh, before I can do that, I'm going to brag on Marshall Wright's people because she didn't do it. 5 of them, is that right, are deployed in Joplin. Correct. Helping out with the efforts there.
Yeah, I don't know how much is in the budget that we put in there for the DC firm you just now talking about. Go ahead and
the Sonosky firm, all of that, it's not broken down by firm, it's broken down by different category, and I'll just have to get that to you. We have an outside counsel litigation fund, and then we have a fund we call the Constitutional Defense Fund, which is was earmarked by this council for things associated with Friedman case. So we have a couple of...
You haven't looked at it? You haven't looked at the fund, the amounts yet, in the budget?
Yeah, that's good.
I have a budget officer, and my executive assistant keeps track of that from month to month. I can tell you that I just looked at on my BlackBerry the last bill for this firm, and it was $1,200.
Okay, how much do you anticipate?
I have no idea. I think the best way to respond to your inquiry is to look at those budget items and tell you how much we've got left in the fiscal year for each one of those.
Well, I'd kind of like to see what the contract is, because last time I asked questions about like the Freeman case and Sonosky Hamlet and all this, I was seeing bills that lawyers were charging $700 and $800 per hour.
The DC lawyers are expensive.
And I have a hard time paying a lawyer $800 per hour.
As do I. That's why we try to keep those expenses and with those outside firms to a minimum, and why we do as much as we can in-house.
Perhaps you can explain this to me. I guess I should ask Tyner or somebody, or when I'm on the council. When I looked at the bills, it said copy room employee or something. It said $125 an hour. Is that really what we paid? Is that what they bill us for, the person that makes copies?
I don't know. I don't know without looking at it. I do know that $125 an hour is probably a paralegal or an assistant.
No, they said, no, the paralegals was more. And then it would say like mail employee, mail room employee, $225 an hour. So I mean, that really is the bill going to us. Would you please get me a copy of that contract?
Absolutely.
Because I have a hard time explaining.
The amounts spent and the amounts left.
And hourly, what we're billing for these people, if this is still the same or if it's gone higher, because these contracts was a couple of years old.
It stays the same annually. If I recall correctly, we negotiate it every year. I'll get you the latest version and how much is left in both of those counts.
Okay, thank you.
You're welcome.
Mr. Bezer?
Diane, I don't know if this is the time to look into this situation either, but the other tribe here in town, they are claiming IR roads within our jurisdictional boundaries. They're also getting an allocation for those IR roads within our jurisdictional boundaries. So this may be the time that we may want to look at that situation also. So.
I know that Mr. Ragsdale has been keeping track of some of the federal grants and federal monies that they've been awarded or asking for, and we've got some requests into various federal agencies about those things. So we try to stay on top of it, but that's a very good point.
Thank you.
Ms. Gloria Jordan?
Yes, Diane, when you provide the copy of the contract, will you provide the past expenditures to that firm and maybe what those expenditures were for? Were they for the Freeman issue? Were they for this issue? So we can maybe maybe you could summarize for us what this has cost us to this point.
Certainly.
And then if you would also include on that what you have left in your budget for this year. And if you could calculate, and I know we're asking you to look forward, but if you could calculate what you anticipate when we have the budget process again this year, whether we're going to have to anticipate an increased request for your two line items that you have described, outside counsel and the Constitutional Defense Fund, and maybe just summarize to us what you all intend to be able to do in-house with the attorneys that you have.
Certainly.
I know that's a lot to ask for, but I think we need to be fully informed as to potential cost on
Certainly
this
will.
particular issue. Thank you.
Any other questions or comments? Yes, Mr. Garvin?
I would like for you to comment on this BIA decision that came down this past week, the chances of getting it overturned and so forth.
Well, we feel pretty optimistic because it's such a novel interpretation, and Mr. Hembry in his memo points that out too. There are couple of things that Interior's doing that they've never done before. Agreeing to take land into trust for a corporation, for example. That's a novelty in the United States. This idea of some sort of implicit or inherent authority for an administrative agency or department that's not spelled out, that's a novelty. And of course, we've got a long list of cases that hold that within the 14 counties, the Cherokee Nation is the Indian tribe that has exclusive jurisdiction here. So, you know, we're going to rely on all of those things. I feel optimistic about our chances, you know, and I think it bears saying that, you know, we're not contesting as long as the United Kituwa Band is a separate tribe, their ability to take land into trust. But just like any other tribe, we don't want them doing it within our 14 counties. You know, this is all we have left. So they're either a separate tribe and they should go outside of our jurisdiction, or they're us and they should come back with us, I think. I mean, that's just sort of my personal commentary.
They seem to be a little hard-headed. We've said that before, and they seem to ignore it.
Well, you know, the courts are a little different than the interior administrative process, so I, for one, am looking forward to getting there.
Tom, would you like to comment on?
And just to follow up on what Attorney General Hammond says, that what we're going through right now is a political process. What we're going to enter into is a legal process. And I think clearly that the case law and the precedent set are on our side in this issue. And when we leave the political realm and enter into the legal realm, we'll be on much better footing.
Thank you. I like the way you said that. That's great.
Any other questions, comments? Thank you, Diane.
Thank you.
Good report. Is anyone here from the Election Commission? You have your report. Okay, moving on down to Tax Commission.
Good afternoon, everyone. Ms. Webster can't be here today. You have her report.
Yes.
I'm here to answer any questions that you happen to have. If there's none, I will get out of your hair and let you proceed. Thank you. Have a lovely afternoon.
I guess so. Ms. Hanby.
Thank you.
Well, hopefully I can be as short and sweet as that. So I believe you have my report. If you have any questions, I'll be glad to answer those.
Any questions for Ms. Hanby? Yes, Mr.
I have one. Vicki, I just saw in the report, coordinated discussions between FWHA and some contracts for federal highway funding. Is there a problem that's coming up, or is it just ongoing discussion about contracts?
Well, part of it is due to one of our ARA projects.
Okay.
And actually, Susan Wirt had been assigned to work on that particular project, but it's really reviewing and updating our contracts with vendors after, we went from VIA to Federal Highway, and we had not updated those contracts, and so it's an ongoing process of doing that.
So eventually we're going to be contracting specifically with Federal Highway on the contract dollars.
No, we've already done that. What I'm saying is the contracts that we have with specific construction vendors, those contracts had not been updated to some of the
Oh, I see. Okay.
provisions with Federal Highway.
All right, thank you.
Any other questions? Thank you, Ms. Hanby. Is anyone here from Gaming Commission? We don't have the report either. Mr. Hembry, codification.
The codification is, again, almost complete. I did have the opportunity to see the our Westlaw representative. I was attending a seminar in Minneapolis, and Westlaw is based in Minneapolis, and he happened to be there, and we had a really good conversation about the items that they needed to complete an estimate on the cost. We have gotten him got to him those items, and we expect this to be complete real soon.
Any questions for Mr. Hembry? Thanks, Todd. Mr. Enlow? There you are.
I was out of camera range as well. Good afternoon. Didn't submit a formal report this month. Don't have a lot of updates from last month. I believe David Justice reported for me last time as I was out of town. But our 911 data processing, the map is very encouraging. There's quite a few updates that have occurred just over the last couple of months. We will run that report again so you can see the changes from original map to current map. And the other thing I would let you know is right now we're looking at about an estimated $60,000 to complete the project. About $25,000 for Nowata and McIntosh County. Those are the two counties that we have always said were going to be our true problematic counties for 911 addressing. And we're estimating we need a backup plan for Adair and Sequoia County. And so that would be the difference to make up the $60,000. It's going to cost anywhere around $28,000 to $30,000. So that leaves us a little bit of wiggle room on those potential contracts. But we've done the analysis. We could staff it ourselves or contract with SDR, which was provided in last month's report. It's cheaper and more efficient for us to contract with SDR. They're the company that does the 911 addressing for all of the counties around us at this point anyway. So that's kind of where we are. We will submit our funding proposal to IHS, and we expect that will get funded, and we should have good news by next month on the funding of that project. But our goal is to have everything done by May of next year.
Any questions or comments for Mr. Enlow? Yes, Todd?
Yes, Todd. Recently, the Oklahoma legislature went through their redistricting process and reinforcement process, and it's now complete. I was wondering if we could have someone study their process.
Absolutely.
Exactly, how they did it. They did it with not much fanfare, and although Cherokee County was kind of carved up unnecessarily, in my opinion, but that's an aside. But they did do the process, and if we could have a staff member just do a memorandum on exactly what they did all the way through, maybe that'd be
Okay, we'll have that for you next month. Good idea. And one last thing, those of you that are serving on our meetings, just a reminder that is next Tuesday, or the first Tuesday of the month, which will be June 7th, and it's in the Geodata Center at 1 o'clock. Okay, thank you.
Any questions for Mr. Enlow? Guess not. Thank you. Okay. Next item, yes, Mr. Baker?
Yes, Madam Chairman.
Yes.
According to Legislative Act 4207, Chuck, Counselor from Bonita, is on the screen and is not on official Cherokee business, but wants to participate. And I'd make a motion that this body allow him, takes 2/3. I'll make that in form of a motion.
Do I have a second?
Second.
Moved in second. Any discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. Hey, thank you, Mr. Baker. Under old business, we have item 1, an act establishing procedures and requirements for naming of buildings. Mr. Chuck, can you hear? Chuck, can you hear? Hello?
Can you hear me?
Yes.
Okay. Well, Madam Speaker, I'm inclined to table this for another month. I would move for its approval just to get us into brief discussion as we did last week. Is Ms. Ragsdale in the room?
Ms. Ragsdale, yes.
Okay. Again, just to get it, I am content with tabling it another month, but I would like to get into some discussion. So with that, I move for its approval.
Motion to approve, do I have a second?
Second.
Have a second. Okay, Chuck, we're in discussion, you have the floor.
Well, thank you, Madam Speaker, and I won't belabor the purpose and intent too much. Obviously, I feel strongly that the council ought to have a real role in the naming of our public buildings, consistent with what a lot of other jurisdictions do. I was content to allow the administration to develop a policy. I've not seen a policy yet from the administration, so I wanted to ask Ms. Ragsdale where they were on that.
Madam Chair. Thank you. Councilor Hoskins, we have been working on that. However, time ran out on me prior to having a conversation with the principal chief who would be signing off on a policy or reviewing a policy. So I don't have a complete document to share with you, but I am working on that and hope to get that to you as soon as I can. And I do apologize not getting it to you prior to this meeting. Also wanted to let you know that just to let you know what to follow up from last month where we talked about let us do the work. The guidelines have been established and I just wanted to show you this document that I picked up from communications. It involves a lot of the different departments, and so what I was trying to pull together in that policy so that you all would see is all of these things that they look to the naming of a building or what they take into consideration. So basically, our position is that to remain in a policy, and yes, it is the council's prerogative to name, but all of the work that goes into it prior to it getting to you is what we would like to take time to do. A lot of research, a lot of historical relevance goes into the location, etc. So that is what we're trying to compile to lay in front of you. And also, once that research is done, I'm positive the principal chief will share that with the council for their considerations.
Madam Speaker, if I could follow up.
Yes, please.
Thank you. First of all, thank you, Ms. Ragsdale, for the work on it. I appreciate that. I am content to take it up next month. But let me be clear that nothing in this legislation would hamper the administration's ability to continue, its good work to develop names, identify the appropriate names. What the act would do is it would prevent the administration, this administration or any, from publicly pronouncing that a building has a particular name without the act of council. That's very important in my view, because if the administration has its work group, develops its name, determines that a name should be placed on a building, and then publicly announces that name, really there's not much left for the council to do. Certainly we always reserve the right to use our legislative ability to impose a name, strike a name. That's not really the issue. The issue is whether the administration should publicly pronounce the name before the council has weighed in. Under this legislation, no name could be, apart from generic names, no name could be publicized unless it was by act of council, again, apart from generic names. What I would expect from the administration in terms of a policy would be one that embraced much of what I have in this act, particularly stopping it from, again, publicly announcing a name until it at least has given the council a reasonable period of time to review the name and the basis for the name. So with that said, I trust that Paula will work on that and bear those things in mind over the course of the next month. And with that, I move to table.
We have
Just one follow-up to provide some assurances. Councilor Hoskin, if you recall, the principal chief mentioned in the State of the Nation at last full council, he apologized for that not coming before the council prior to the naming of the clinic in Bonita. It was just an oversight, was unintended. And I just want to assure this body that the principal chief has given his word and expects anything as important as naming of a building to come before this body for consideration. I just want to follow up with that.
I have a motion to table and a second. All in favor signify by saying aye. Aye. All opposed, same sign. Table till next month. Item 2 is an act requiring elected officials to undergo random drug testing. Mr. Crittenden.
Thank you, Madam Speaker, Madam Chair.
Sir.
We've discussed this the last couple of rule committees we've been in session in. And from the get-go, my efforts have been for fairness. The employees undergo random drug testing. I have a copy of I think the latest policy here, and signed with the chief, and it has several sections in there, and I think it's a good policy. And obviously he does. He's made the statement and wrote a letter over here to us that he submitted to a test and it passed in the past. I see no straying here from what our employees are required to do. And so if we're all in the same boat, and I think we ought to be, I think we ought to actually have to go through the random test just like our employees do. And so for us to be able to discuss this, I'm going to move for approval, and we hopefully can have a little discussion because there's 2 or 3 more acts here dealing with the same thing.
Motion true, and second? No, not a second. Do I have a second?
Second.
Moved in second, now discussion. Ms. Cope?
Clarification.
Yes.
Is it the original one that you submitted, or is it the Hoskins substitute?
It's the original one that I submitted, Mr. Mayor.
Ms. Coates?
I applaud the attempt to equalize things among the employees and the elected officials, but a legislative act doesn't do that, because employees at this time undergo what is a policy, and a policy can be changed, and it's my understanding that the administration is in the process of reviewing this policy, and that there will likely be changes in the coming months. Is that correct, in my understanding?
That's correct.
Essentially correct?
That's correct, and at the appropriate time, I'd like to talk for the administration.
Okay, and if that happens, then what we may very well be left with as legislators is something that is more binding legislation, actually, that in fact is going to differ quite a bit from what the policy may end up being for employees. And we won't have nearly the flexibility to be able to make changes, to bring it into alignment with what the policy may become. Policies are changed within administrations, from one administration to the next, but legislative acts are more difficult to come by those types of changes. And so while I applaud the effort to equalize the situation between employees and elected officials, this act doesn't in any way do that. This act, in fact, puts a much more stringent standard onto elected officials and denies the flexibility of change that we would have under employee policies. I also would object strenuously to the first version, the original version. I think there are real constitutional problems with it. I suspect that's why Mr. Hoskins attempted to make some revisions to it and so forth. And so, given the problems, given the objections to an act versus policy, I will not be voting for this. Thank you.
Yes. There's only one problem I see with it. I don't mind taking drug tests. But the thing is, if I'm out visiting a constituent, or I'm home on the job working, or I'm in Oklahoma City, they call me to take that drug test, what's going to be the policy on that? Do I have to leave at that moment to go take that drug test wherever I'm at? Or are they going to take that drug test when we come into meetings and we're hearing telephone? What are you going to do about it?
Well, I suppose we'd handle it the same way we would an employee, maybe that's out in the field doing something for somebody. I don't know exactly how they handle all those situations, David, but surely they've got some policy in place to handle that kind of thing, because how would they know whether an employee that's selected on a given day is gonna be sitting in their office behind their desk or whatever? I mean, they can be in the field too. So I don't know.
Well, that's what I'm asking. If
Yeah.
I've got personal business out here and they call me for a drug test, does that mean I have to leave there and come to Tahlequah at that time? You know, where are we gonna set a boundary here?
Mr. Thornton?
I mean, I don't-
Thank you, Mr. Ragsdale.
Madam Chair, if I think I can answer your question. If you applied the same administrative policy, and I want to talk about this a little bit more, Madam Chair, when, at the appropriate time, you would be required to leave that area and report to a central location and be drug tested. That is a requirement for all employees, and it's a matter of fact, one of the reasons that we are looking at we have a rather robust drug policy as mandated by the federal government, but we're in the process of reviewing our policies and going through the pros and cons of all of it. But if you applied the administrative policy and you were meeting in Sallisaw with somebody and you got randomly selected, you would be required to report to a drug testing site designated by, if it's for just the legislature, designated by you, or use the administration's independent test system. If you were involved in a wreck, and even if there was no reasonable suspicion that you were under the influence, you would be required to report to a drug testing facility and be tested. That's automatic.
If you're in Oklahoma City, Tulsa, California, if you
Accommodation.
Washington, D.C., and you're called for a drug test, what are you gonna do?
Well, in those
Report
instances,
there to a hospital and take a drug test?
in those instances for administration's employees, because my wife has been subject to it, and is that they have required her to stop what she's doing and report to a testing facility in the Washington DC area. And I assume there's enough of these across the country that it is feasible, sometimes inconvenient for people that are on business, but it can be done. That's one of the things that we are reviewing ourselves.
Thank you, Mr. Thornton.
I wouldn't mind if I'm in my district, taking a blood test or other type of test, but, I don't, if I'm off somewhere vacationing and they call me to have a drug test, I'm not gonna be for this. So, that's the way I feel about it.
Thank you. Ms. Gloria Jordan, and then Mr., you have your hand up, Mr. Garvin, okay.
I guess this question would be for Mr. Ragsdale. What if they can't get a hold of us? I mean, when I go to the courthouse now, I don't take any phones because you run the risk of being found in contempt if your phone goes off in the courtroom. So sometimes I don't have my phone for a day at a time.
I would assume that, we would look, if you were an administration employee, the HR department would look at those instances, and I'm sure that if your cell phone was on the fritz or you didn't happen to have it with you and nobody else could notify you, you would not be penalized for it, but might be subject to a random test at a later time. I mean, that's another thing that we're looking, if we keep the random testing in place, which we're talking about maybe modifying, that, we want to look at. Because it is, it doesn't happen very often, but it is inconvenient if somebody calls you and you're in Oklahoma City or Tulsa or someplace else, and you got to stop what you're doing and go take a drug test. I would add that the chief and the deputy chief have voluntarily submitted to the process because, they direct the administration and what's fair for the goose and fair for the gander type principle. So they are adhering to our current drug policy, even though they're not required to.
Mr. Garvin?
Yes. We've had the Cherokee Council for many years. I just wondered if they've ever been a council person accused or proven to be on drugs. Does anybody know anyone on the council ever been suspicioned? I kind of look forward to taking that test. Do they have a witness in there watching?
Do you count acting crazy sometimes like you always?
Switch it off.
I think questions don't
Bring
shoot
a
on.
bottle in with you.
Mr. Hembry? I mean, not Mr. Hembry, Mr. Hoskin?
Thank you, Madam Speaker. I will be brief. I have great respect for my colleague Joe Crittenden. I know his motives for this are very good. He's concerned about fairness. He abhors the use of illegal drugs. Certainly, I just have to rise against this, mainly on the basis that I'm uncomfortable with the executive branch policing the legislative branch on a subject which could lead to impeachment, removed from office rather. So while I sympathize with his concerns, I can't join on this one. Thank you, Madam Speaker.
Yes, thank you.
Madam Chair, may I just say very quickly, the administration has not proposed any one of these three bills, and I will address that later. But I just want to make clear, this is not the administration's proposal to require the legislature to adhere to a drug policy. That's your business.
Ms. Fishing Hawk?
I got a couple of questions. Where's number 3, Miracle? I don't have number 3 we're talking about.
I think it's the Hoskins substitute. I have a copy of it, Joe.
I don't have a copy.
It's in your folder.
I don't know that
Which
it's...
one?
It's right after that pink page.
It follows Mr. Crittenden's bill, which is then followed by Ms. Coates's bill.
And then I've got a new version of Ms. Coates' bill, looks like here. Possibly.
Okay.
My other question is, I can't remember, why did we take marijuana off the illegal drugs? Anybody?
It's not the administration's bill.
Marijuana's still on theirs.
Huh? Marijuana is still classified as an illegal drug. I think that is open to discussion, but the fact of the matter is, which I was going to address later, the fact of the matter is we are required to be in compliance with the overall federal drug policy and drug-free workplace when we take a grant and sign for the grant. And it's my opinion, so long as marijuana is listed on the controlled substances, we would be prohibited from removing that, even though an argument can be made that it's no more harmful than alcohol and so forth, and that may be a valid argument, but until such time as Congress or the states prohibit the use of marijuana, I think under our federal grants and compliance requirements, we would be required to continue to ban it from our workplace.
Okay, so that's because of the federal.
And I haven't talked to Ms. Coates about it or anybody else about it.
We're not discussing point of information, though. We're discussing Mr. Crittenden's at this moment, not mine, so.
Okay. The other thing is, I'm confused with all these acts. Tell me where like mushrooms fall in.
I'm sorry?
Tell me where like mushrooms fall in.
There are some, it's been a while since I had my drug training when I was in the police officer, but there are certain types of mushrooms that are prohibited substances. There are certain exceptions to the use of peyote for religious functions and things like that, but I'm not the expert on that. But the way that the administration use it for executive branch employees it's a very tight list of those items that are controlled substances.
Okay, so that's what I was wondering about, because I know we talked about peyote the other day, and then there's mushrooms, and they're two different things, but when you can smell colors and see odors and touch light, to me it's a drug. I realize, it's mushrooms, it kind of falls in the peyote category, but it's not peyote, there's a little difference.
No, I didn't mean to imply that, yeah.
Okay, thank you.
Yeah. And there are mushrooms that are on the controlled list. I can recall that one from my police training.
Mr. Thornton?
Yes, so if jellyfish is at random, does that mean that there'll be so many counselors picked up one month and so many the next month? Are they going to do them all at once, or what do you mean at random?
The way Madam Speaker, if it's okay for me to respond, I can just tell you, the way we do it in administration is that our computer, and I used to accuse my son-in-law of fixing the computer to make me get tested more often than not, but he hadn't done that to me lately. Our computer randomly selects approximately 5% or 10% of our total workforce during the course of the year, which means the way the computer system works is you might get hit, like I used to get hit, Todd, with about three drug testings within a year, or you may not get tested at all. It's set by the computer so that nobody's in control of saying that Mr. X or Madam Y gets tested without reasonable suspicion, which is another category.
Now, Mr. Clinton?
I think everyone should be tested, it's only counselor for one test. I think it should be 5% a year or something like that nature.
Mr. Crittenden?
I just want to make a comment. Pat, I'm glad you're here today because of the answers that you give with the administration, knowing that they're on travel a lot, and which would apply to us maybe more than somebody manning a desk or something next door or somewhere. And, I think this can be done. I think that with you all looking at it from your perspective and what's fair with the employees, and then as long as, from my perspective, as long as we're all in the same situation, I think it's a great deal. So I appreciate it.
Well, I think the administration would appreciate the council, although the council, again, is not mandated to do this. Congress doesn't do it, to my knowledge. It'd be great to be consistent. What the administration would recommend is that we've got 3 bills. We have some issues with every one of the bills that have been drafted, which, is the nature of policy making. But we would invite the council to designate some folks to sit down with us and go through the drug policy that we are mandated. And we are mandated to have a drug policy. We have quite a bit of flexibility as to how we're going to administer it. We have 2 policies, one for DOT, what's called the DOT policy, which is a very strict policy for those people that are operating heavy machinery or driving as their primary duty. And they have a stricter policy than the non-DOT policy. So the policy that we're looking at specifically for Cherokee Nation employees is the one that we have derived over the years as administration policy that is consistent with the federal policy that we have to follow.
Anything further?
So, it sounds like that everybody's kind of wanting to work on something that would fit all of us possibly. Is that what I'm hearing? Rather than just one act or another act or whatever? I'd be willing to, from my thought, I'd be willing to do something like that. Maybe a group of folks from us and them and whatever. Good, yeah, let's take.
I'd make a motion that we table this one.
That's okay, I'll second.
The motion to table?
How long do you think you need to work on it?
It's hard to say as long as we get our group together and decide something. So at least 30 or 60 days or something maybe, I'm not sure. Now, what do you think, Pat?
If we could start talking informally, I would recommend we give ourselves about 60 days.
Okay.
And the council's always free. This does not require legislation. You can adopt it by rule, just as the administration is adopted by rule. But I think it's a good idea that we try to be as consistent as possible, so long as the council wants to do that. And we'd certainly like to have your input about what we subject our own employees to.
60 days.
We have a motion to table, and did I have a second?
I did. Did you have something?
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries, and it is tabled for 60 days.
Thank you, Madam Chief.
Thank you. Item 3 is an act requiring drug tests for employees to be based on warranted and reasonable suspicion. Ms. Coates.
I will follow suit, and I will move to table for the same length of time, whatever, I'm still not clear, but
60 days?
60 days, okay, as well.
Okay, 60
I'll second.
Mr. Emery?
Just for a clear legislative record, instead of 60 days, let's say table to the July meeting, July rules meeting.
Yes, sir.
And you didn't have a second yet, did you? Did he? Okay.
We table to the July meeting. We got a second.
Yes, I second.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carried.
Point of order, or point of clarification. What do we do with Chuck's amendments? Are we also asking that the Hoskins substitute, are we asking that that be tabled, or?
That's
not- Are they together?
It's
Which
not
is
on.
Madam Speaker?
It's fine.
It's not on, it's not on the agenda.
Madam Speaker?
Yes, Mr. Hoskins, sorry.
Well, I'm sorry, I guess you've already said it, but that draft was merely offered as something to consider in connection with Council Crittenden. It was not meant to be an item on the agenda, rather just something for us to look at.
Okay, thank you, Mr. Hoskins.
Thank you.
Item 4 is an amendment to the Sovereign Immunity Act, and we have Mr. Carson here. Thank you for gracing us with your appearance.
Thank you, Madam Speaker. Good to be back and good to see a lot of old friends. I've been here before talking about the New Markets tax credits. CMB was allocated $60 million by the U.S. Department of Treasury to use these tax credits, which were first initiated during the Clinton administration and are widely seen as the most powerful federal government tool for economic development. CMB was the only Indian nation entity in the country to get an allocation in the last round of these, and CMB was given $60 million to promote economic development. We're here today to talk about a very technical change to legislation that I was before this council a couple of years ago. Sovereign immunity is obviously deeply cherished by the tribe, and waivers are granted with only after deep contemplation. There have been a couple of waivers that have been granted or exceptions to sovereign immunity that this council has approved for business purposes over the last 2 or 3 years. One of those was an exception for the Small Business Administration. Many of our companies are 8A. They have to, as a matter of course, sign waivers of sovereign immunity with the federal government, and we granted a blanket exception to the Sovereign Immunity Act for them. At the same time, for construction bonding, when C&I was getting into construction, Cherokee CRC remains in that field. Bonding was required, and a waiver was granted then. And important to recognize in both of those cases, it wasn't a blanket waiver. There were things, though, that the chief could sign at the recommendation of the boards of directors or the businesses after a lot of negotiation. These new market tax credits, there are a number of deals pending that will bring economic development to 14 counties, one in Adair County, one in Muskogee County, that are still being fleshed out, but that we're optimistic about. And they will require, because of the sophisticated parties involved, a limited waiver of sovereign immunity. And that's what we're here today to advocate for. The proposed language here is just behind Roman numeral 2 here. It just says, if you have a copy of the legislative details for you, the brief phrase after the second small Roman numeral, to accompany in connection with new market tax credits transaction, is the only change to the legislation. It's important to recognize here that what we'll be doing in practice. Again, we will be offering, these waivers are necessary because in these complicated deals, a certain indemnification of the parties is required by CNB. The indemnification is not about the business risk. We're not verifying the particular company is going to succeed. And we're not liable if they succeed or if they fail. What we are instead saying is that we have various entities established, various companies, if you will, community development entities, of which we have a board of directors of community representatives, that will keep these kinds of businesses ongoing, that will follow the proper paperwork and a few things like that. So some very technical matters that are largely within our hands that shouldn't expose us to any liability, but in case we act negligently ourselves and not keeping these entities ongoing, we do indemnify the parties. So that's what we're here today to ask for. The board of directors of C&B, of whom I'm representing today, is aware of these kind of requests. We're approving them and are in support of it.
Mr. Baker?
I make a motion that it be approved.
Second.
Moved in second. Any discussion? Exciting that you have 2 or 3 already in the process, don't you?
We do indeed. I mean, even with CMB board meetings, as several of you have been, you know that they're ongoing.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carried. Although it is an act, we did it by acclamation. Okay?
Thank you so much.
Thank you for being here, Brad. Okay, item 5 is discussion regarding the administration use of contractors to conduct focus groups and opinion surveys. Mr. Hoskin?
Madam Speaker, I would move to withdraw this item with the consent of Councilor Lord Jordan, who I think is my co-sponsor. We can revisit this at another time, but I'd yield to her just one moment with your concurrence.
Yes, I would second that.
Yes, she agrees to withdraw, Mr. Hoskin.
Thank you, Madam Speaker.
Item 5 is withdrawn. Under new business, we have, we've already done items 1 and 2. We'll move on to number 3, a resolution authorizing donation of surplus equipment to Flint Ridge. Mr. Buzzard.
Now, this is a piece of equipment that Flint Ridge is needing to complete the rural water system development in southern Delaware County, which serves Leach and focus on to West Silent Spring, Colcord, and that regional area over there. And it's a piece of equipment that goes in and clarifies the water. So it's a donation that we had got donated several years ago. It went to Weber's Falls, never used it, so they just returned it back to us. And so I'd make a motion that we approve this resolution.
Moved in second, discussion. Mr. Crittenden.
Madam Speaker, since that's up there in our new area and all, I think I'd like to be added as a sponsor if I might, Carly.
Sure.
If it's all right.
Got that shut. Okay. Any other
I think
discussion?
Jody also asked that, but she's not in the room right now, but probably Kurt too, maybe if he
Yeah,
was
that'd be
here.
fine. Just anybody wants to be co-sponsor.
Anybody not want to be a sponsor?
It's actually close to our area, so I'd like to be added as a sponsor.
Anybody not want to be a sponsor? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. The item 4 is an act declaring resolution 1797 and 697 void. Mr. Baker.
Yes. These are acts that we had discussed before that were passed by council when there was not a quorum present. And hopefully this would clean up be able to clean up Legistar and so forth. So I make a motion that it be approved
Second.
By acclamation.
by acclamation.
Okay, any discussion?
Yes.
Yes.
I have a question about the constitutionality of the method that we're using to clean up the legislative record, and I would like to ask Todd to speak to that, the possibility that this might be considered a retroactive law.
I haven't been asked that question in the past. Obviously, so I cannot answer your question at this point. If you would wish to request a legal opinion on it, I'd be happy to do some research on it.
I would like to ask for a legal opinion on this because I really think we're getting into an area of a constitutional question. You did not prepare this?
No, the author, I believe, is listed on the act. It's Melanie Knight.
Okay. I think we're treading into some dangerous water constitutionally. I realize we can repeal, I realize we can amend, I realize we can pass a new law, but the method by which this is being done is very unique and unusual. I'm not sure what other jurisdictions have ever utilized this. I don't believe we've ever utilized it. It doesn't appear since this happened in 1997. I feel certain, since it's been there since 97, that if we took a month to allow our legal counsel to give us some advice, it certainly would be prudent on our part to do that. So I would make a motion that we table this and give our legal counsel 30 days in which to give us an opinion memorandum, much like he did on this last issue, and take it up at next month's rules, if that would be a possibility.
Second.
Moved in second. All in favor of tabling, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
The opposition, you want a roll call?
I certainly think it would be judicial on our part to listen to the man that we pay to give us legal advice. Todd, do you not have,
Ms. Gloria Jordan, we've already taken a
Point of
vote.
order. Well, can I continue? I mean, I thought I was continuing with my discussion.
No, you don't have discussion on tabling. You make a motion to table, then you second, then you take a vote.
Well, I was, if the chair would indulge me, I thought I had the floor and I was just going to ask him for his opinion on this method to correct a legislative record.
Well, First on where we're at parliamentary procedures wise, is that there's been a motion to table, it has been seconded, and there's been a voice vote. The chair has declared the voice vote to be in favor of not tabling, is that correct?
So it's still in discussion.
So,
Hold on just a second. I can't listen to both of you.
I will
We
defer
have a
to,
motion to table, and it was second and approved apparently, unless she wants a roll call vote.
no, the motion to
Table.
table, was it the chair's decision that tabling passed or tabling failed?
I said tabling passed.
Okay.
She questioned it.
Okay, well then the matter's tabled.
Tabling failed.
I mean, tabling failed.
Okay.
I'm sorry.
Well, in that case, what can happen right now is either a division of the question and a roll call vote on that, or discussion continues.
Okay, Ms. Gloria Jordan?
Can I ask for clarification on division of the question, what he's,
Mr. Embry,
Yes.
she has a question for you.
you mentioned division of the question, explain that to the body.
I misspoke. It wasn't a division of the question. It was for a motion for roll call vote.
Right.
I
I was thrown on
misspoke.
that one too,
Yeah.
Dinah.
I'll go ahead and ask for a roll call then.
Okay. Yes is to table, no is to not table. We had a motion to table and a second. Okay, and if you vote yes, that means you agree to table. All minds clear? Okay, Miss Roll Call.
Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Gloria Jordan,
Yes.
Chris Sup,
No.
Curtis Snell, David Thornton,
Yes.
Kara Cowan Watts,
No.
Bill Anglin,
No.
Bill John Baker,
Yes.
Jack Baker,
No.
Harley Buzzard,
No.
Julia Coates,
No.
Bradley Cobb,
No.
Joe Crittenden,
Yes.
Jody Fishinghawk,
Yes.
Meredith Fraley,
No.
Janelle Fulbright. We have 6 yes and 9 no.
6 yes, 9 no. The motion to table fails. Thank you. Yes.
Other counselors get time to talk?
Yes, you
Okay.
had your hand up a while ago. Go
Okay,
ahead.
thank
And then
you.
Mr. Hoskin, are you there? Can you hear?
Yes, that's me.
Okay, Miss, you'll be next.
Very good.
Thank you.
Madam Speaker, thank you. I'm still struggling with how this was even put on the books, how these council people even thought without a quorum that this was a legal act. Do we have documentation of that too, and what was on the record at that time?
Ms. Knight, are you going to respond, please?
Yes, Madam Chair, thank you. Yes, there are minutes of record that are within Registar. Some of them are cut off on the edge, but there's enough of the minutes available to determine who attended, how many attended, and the actions during those sessions. And I believe I've distributed those to committee over a period of a couple of months.
Okay.
Yeah.
Thank you. Thank you, Madam Speaker.
Mr. Soap?
Yeah, in our notes, we talked about there happened to be a quorum and so forth, and the question is, how does this law even in our record? And because it exists, what things can we do to make sure that this doesn't happen again if it is out of compliance and shouldn't even be in our record? I don't know if that's to you or Todd or
Yeah, I know. I'll ask Todd to answer after me, and I'll take a stab at it. I'm not sure there's a clear answer to that. If there were a gathering without a quorum that happened today, I'm very confident that a similar thing would not have happened under the governance of this body.
Madam Secretary, I mean, how can we be confident? Because I mean, the same rules applied then, it's my understanding, it's the same rules applied then as they do today. So how can we be confident that, you know, we couldn't just go down there and put these in the file folder and say, well, these are the laws and you have to abide by them?
I think that's a very valid question, and what kind of protections could we put in place, and I would kick that to the council.
The protections that are in place is the Cherokee Nation Constitution. If something like that were to happen in the future, a question on a quorum, well, that's why we have an independent judicial branch. We would file an action with that, and the court would rule. Much in the same instance that has happened in this instance. There was a later case that held that a quorum of the tribal council was 2/3 was 10, and therefore, based on that court case, we had already flagged these acts.
So it was defined at that point.
Right, yeah. And believe you me, in our constitutional convention, when we were determining the quorum, there's extensive legislative history as to what that quorum would be. So therefore, the actual process is the Constitution itself.
Okay. Unfortunately, that decision occurred a long time ago, and why this remained on the books, I think is unknown to us.
Well, the reason it remained on the books is that it was a passed act through the legislative system during and through the codification process, as I stated, that we had me and Mr. Morton in the Attorney General's office and several others have went through every legislative act that has been passed for the last several years. This was one of the acts that we flagged that had a question of constitutionality, and in our codification finale, we were going to ask for that act to be repealed.
When back in this time period, did they have a legal representative such that we do? So like if we have a question, we ask our legal expert to advise us.
Yeah.
Did they have that during this time? And if they did that go, what was his advice in error, or was it something that just was ignored?
No, at the time of this, and I've reviewed the minutes and through just historical knowledge, the council did not have a full-time attorney, but they had outside counsel, which Mr. Seymour was that counsel. He gave a legal opinion. Was it?
My counsel.
Well, I mean, they had outside.
was on board too. He was counsel for the nation.
Okay. Well, there was a legal opinion rendered. I will say that.
Okay.
And that legal opinion was that from Mr. Seymour was that the quorum, that 9 was sufficient for a quorum. So they followed their attorney's advice. And then that opinion was later held to be not the law.
Okay. So we really don't have any protections in the sense that I would think that today you would be a insulating layer of protection for us to not go down that route. But if you tell us it's okay, and then we say it's okay, then is it potentially the same system all over again? Because the rules really haven't changed, have they?
Anyone can, yeah.
Still says.
Sure. And that's the whole theory for the checks and balances in a 3-branch government. You have in-house counsel today. I can give you an opinion. I'm not perfect. My opinion may be wrong. If you follow my opinion, that happens to be wrong, and someone questions it. That's why we have a judicial branch to bring suit and say, counsel, you followed the wrong advice. Obviously, it would be my effort to give you the best advice that I know, and I would be believing in the advice that I gave. But if I happen to be wrong, since I am not perfect, that's why we have the people in the black robes to make.
So we need to make sure that we keep the judicial branch there to
absolutely
determine what is right and what is not.
And then follow the directive of the judicial branch.
Yeah.
The system worked. The system worked, she just failed to abide by it.
Okay, thank you.
Call Mr. Soap.
Yes, ma'am, thank you.
Mr. Hoskin,
Yes, Madam Speaker.
your turn.
Thank you very much. I have a question for Mr. Hembry, then I have a comment. Mr. Hembry, the legislation, the acts that are the subject of this legislation were struck down by the Judicial Appeals Tribunal, is that correct?
Not specifically. There is the case that was rendered was on a different matter, but it held that a quorum of the council in session at that time was 2/3, which was 10. So therefore, although not directly overturning, this particular act or resolution, that precedent would dictate that the same result would go forth. And that is one of the reasons why we had already flagged this act.
I guess I have another question. In the course of codification, were you guys, those that are involved in codification, did you not plan to scrub these acts from the record on that basis?
That was going to be my recommendation. That still is my recommendation.
Okay. We already have a process in place, Madam Speaker, to take care of acts that are null and void. I think this legislation is completely devoid of any legal substance and is completely unnecessary. I think it would behoove us to reconsider Councilman Jordan's advice that we table for a month, because I do have questions about the constitutional issues she raised, but frankly, this is completely devoid of substance. I mean, courts in this country, in the states, in the United States, strike down laws all the time. They make rulings that effectively render laws null and void. It happens all the time. Wisconsin is a good example. Wisconsin's legislature passed, and its governor signed what was essentially a union-busting law. That law was found, I think yesterday, to be null and void by a district judge in the state of Wisconsin. That'll go up to Wisconsin's highest court. If that ruling is upheld, that law will be null and void. There won't be any need to revisit it in the legislative process, because by operation of that judicial opinion, the statute is null and void. I'm puzzled a bit. Maybe I'm being a bit facetious, because I actually don't think I'm puzzled as to why in May of 2011 we are bringing this issue up in an effort to hastily scrub the legislative record. But in terms of legal substance, this legislation is bankrupt. It has none. And I will vote against it for that reason. Having said that, I think I should be a bit more measured in my tone, and I would move again to table it, because I will give it some more consideration, but as of right now, I think it's devoid of substance and would vote no. So I would again move to table.
Have a motion to table
Second.
and a second. All in favor, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Mr. Hoskin, sounds like the ayes opposing have it. You want a roll call?
Yeah. From where I'm sitting, it sounds like I won, Madam Speaker.
Okay. Okay, we'll do a roll call.
No, I don't need a roll call. I appreciate it. It's probably the acoustics of this room. But Madam Speaker, I will vote against it. Thank you, Madam Speaker.
Thank you, Mr. Hoskin. Ms. Fishing-Hawk.
Todd, I was out of the room and part of this, and I heard that you got with the Attorney General, and you basically said we don't even need to do nothing with this, because during y'all's process, y'all scrubbing it through codification.
And I've made that statement
That's in a nutshell.
previously.
Okay, because to be honest, folks, I'm a little, not quite nice as Mr. Hoskins. I'm much comparing this to the meeting up at Hard Rock, where there was a quorum of the subcommittees, and the excuse was ignorance of the law. I don't think it's any different, folks. I think it is political, and I'll call it what it is. It's political. Y'all want to make a little hay and get something out there. And this is bull, for lack of a better word, because I'm sitting here and listening to some of y'all lie after I got the tape that said you wasn't there. So I think I just want to go on the record as what this is. Call it what it is, folks. Thank you.
Dr. Cobb?
No, ma'am, another question.
Okay. Mr. Garvin?
Mine was answered with Mr. Sullivan.
Ms. Count Watts?
Thank you. I've really struggled with this because we do try to be transparent and like get all this stuff out on the table and the actions that's been taken by this body in a public meeting, whether it was legal or not, I guess, in a quorum at this facility or over at the other. So if you read the definition, and my Latin's horrid, but void ab initio means null from the beginning and seriously offending law or public policy. And I think it's imperative for this body to put on record, and since we have Legistar, which really makes our process transparent, and I'm excited about it, we should set a new tab or something where you could query by just this term for such documents. So that if there's ever a question because somebody gets a hold of an old document, maybe that's hanging around in their family or the newspaper or something else, and it's very clear when they research on Legistar that actual outcome within our policy of this body is that we actually use a term or something meaning this term that is null and void from the beginning. There may be some record of it because as a body we're transparent. This activity or choices in the past took place. It was horrendous. It was offensive to our Constitution during that time, the constitutional crisis, and the people that participated in that, they need to know who that was. So we need to be very clear within Legistar that we actually show that this occurred, but that it has never really been recognized by the Cherokee Nation as anything in the legal sense. Thank you, Madam Speaker.
Thank you, Ms. Watts. Mr. Baker, Jack Baker?
Yes. Should this act pass today or go to full council in June, and I would assume that since we do have a legal counsel, that he would look it over and give us advice at the June council meeting if there's a problem with it. So I would hope that he would do that. Thank you.
Are you pressing to do that?
Yes.
Thank you, Todd.
I would ask-
Mr. Thornton?
I've got a question for Todd.
Yes, sir.
Todd, since you've been through these acts, and resolutions and laws, and are these the only two that you've run onto, or is there more?
It's the only two.
It's the only two in there?
That's the only two that I could find. Yeah. And we went through it pretty, well, we've all gone through it.
Well, in your opinion, were they legal or illegally acted upon?
Oh, I've already given you, and I've stated before that, is my opinion that they were unconstitutional, and I was going to recommend that they be repealed.
Then I'll have to vote for it.
Ms. Gloria Jordan?
I would formally ask, Todd, that you give us a written opinion before the council meeting. It appears that it is that they're going to vote to do it regardless of what your opinion is right now, and even though it's 12 years old or 13 years old, oh no, it's 14 years old, I'm sorry. Even though it's 14 years old, it's such a rush that we've got to do it today without you being able to research it. And I apologize, it seems like more often than not that we tend to ignore your wisdom and legal advice that you give us, and I apologize to you for that. I really don't understand why we have an attorney that tries to give us guidance and we continue to ignore it. I wonder if you all were utilizing your own dollars and you went to a private attorney and he said, I wouldn't do this right now. I wonder if you'd say, well, I'm going to go ahead and do it anyway, and here's your $500 for your advice. I wonder if you all would do that. You continually ignore the person that's giving you the legal advice. It's a continual thing. I will be voting no for this because I really see some constitutional problems with this.
Mr. Anglin?
Thank you, Madam Speaker. I have a question for Todd. Todd,
What's the problem?
if these were illegal acts, why did the judicial system not act on them back then? What was the deal there?
Well, the courts will only answer the questions that are asked them, okay? There won't, you've heard the term judicial activism. Well, they will only, answer those questions that are put forward to them. There was no court case specifically put forward to them on that specific act. Now, they did hold in another case that a quorum at that time was 10. So so in order, for the legal system to completely work, is that you could file a case saying that, these are unconstitutional, here's your previous, decision on the question of quorum, and that therefore they would render, can't guarantee the sun's going to come up, but they'd render the same verdict. So that's why the courts didn't just sua sponte or on their own.
But they did rule that 10 was,
Yes.
and the council just kind of willy-nilly that deal out the window? or
Well, that was after, that court decision was after the passage of that act, I believe.
But yet the record was never corrected
Yeah,
to reflect
right.
Right, yeah.
the ruling of the court. And
So that's why I was
That's part of
wondering
the
why did the judicial system not work?
Well, I think the judicial system did work. Yeah, because it answered the questions that are above, that were before that.
But then we just ignored what they recommended?
No.
No,
Or no.
That council that worked on it.
No,
At that time.
And I'm not, and I would have to help me with the dates.
I would like
on
to
that.
speak to this if I may,
Yeah,
Madam. I was here,
You have about 3 minutes.
I will speak less than 3 minutes. The reason the system broke down because the justices were put out of office and forced out of office by a security patrol. That's what happened. What I don't get is if it's illegal, and your counsel says it is, why you just don't repeal it. What is the constitutionality of repealing acts that shouldn't be on the books? Our government was stepped on its head during that period of time. What is wrong with saying it was wrong and it's repealed? It is done.
And that's not the floor side. I totally agree with that. I think this is something we need to act on. It's gone on too long. Thank you, Madam Speaker.
Thanks, Ms. Franklin. Mr. Soap?
Yeah, Tyler, I heard that you said that the judicial system worked, the legislative system might have been halfway working during that time. Maybe we should have had an accountant on retainer versus an attorney. But the question is what didn't work then? Because we've got something here that we've identified is in our law, and something didn't work. So, I mean, you don't have to take a real long time to write up a summary of that. What kind of failed here? I mean, I think we would walk away from this meeting real clear if we just kind of had an idea.
Okay.
In your opinion, what was the breakdown point in this? Is it our review of what is on the books or what?
That's one issue, and this is a continuing, ongoing situation. There are, in many jurisdictions, there will be laws that are unconstitutional, and they just haven't come about the process of getting them off the books. You can find that in any state. Here the process is that it's been a long time since we did our codification. Okay? The last codification we did was in 1984. Well, we're in that process, and during that process, and this is the legislative, we identified these acts and a couple others that we think are unconstitutional, and we would recommend that you take them off the books. That again is just part of the development of the legislative process. So it's ongoing. So it's and that's the process by which we were about.
So I think what I heard is that maybe the lack of action or the lack of a decision to vote is what's causing these acts to be on the books right now. So
We need to complete the codification process or this act.
Thank you.
Oh, Mr. Soap?
Yes, ma'am. Thank you, Madam Speaker.
Mr. Thornton?
Tom?
Yes.
Well, if you're going through codification of these records.
Yes.
You've got two that aren't legal.
Correct.
Why aren't they brought to the council and voted on to take them off the books?
They are. They will be.
Okay.
Yeah.
That's what's happening now, right?
Yeah.
Today.
Well, I mean that's part of the completion of the
You're not trying to sweep this under the table, or anybody else is trying to sweep it under the table?
Not at all. I mean, because, you know,
It should be brought out, that's the way I look at it.
and it's part of, yeah, that's what I've always said.
And most lawyers that I've personally went to, the ones that helped me, really didn't charge me anything. And the ones that give me the real good advice that cost me thousands of dollars, I got my butt beat. So,
I hope I'm somewhere in
I'm going
between.
to accept your advice today and thank you, and I'm going to vote for kicking this out of the rules and regulations, policies, and procedures, okay? Thank you, sir.
Mr. Garvin?
Stay up.
I think Todd is doing a great job, and I don't have any complaint about that, but anytime he walks in here and gives us bad advice, I got enough common sense to say, no, that's not right. And I think we wouldn't be here today if somebody would have said that. You're telling us wrong, Mr. Lawyer, I don't know where you're from, but you shouldn't be advised that a majority doesn't make a quorum. I know you think it is, but that doesn't make it right. So, even though it's legal advice, sometimes you gotta ignore it and say, no, no, no. Thank you.
Ms. Coates?
I'm going to take a little different perspective on this, that of a historian. This is the constitutional crisis, the era of 1997. We said, my gosh, this was 14 years ago. It was a very important moment in our history, however, as a nation, and historians are going to look at that time for forevermore. They're going to go back and look at it. As a historian, I would, this piece right here, because of the void ab initio, I totally agree with Councilor Watts creating a new category on Legistar, putting this in here. We think that historians look at a different type of document, but this is exactly the type of document that historians go and look at. And they will look at that era from 1997, 1995 through 1999. They will look at what was happening legislatively, politically at that time, of course. And rather than have this buried in codification, which it could be, and it would still go through and everything, but to actually bring this forth, put it very directly into the record as a repeal that was done in 2011 by this council, really brings it to the forefront in a way that I think historians subsequently would really appreciate. They may not get in there and dig it out and see it, you know, in a whole body of codification, you know, legislation that will be subsequently passed, but to really pull it out and single it out in this fashion will I think do a great deal for the preservation in the historic record of this very, very critical point in our nation's history. Thank you.
Thank you. Ms. Fishing?
Todd, the only thing I see problem with this is the method they're going back. Like Pat said, is it not the proper way to ask for a repeal? Is that not the proper way to do this?
Well, I mean, that's one of the requests for the legal opinion that you know, that I will put forward. I've been asked that question, and I'll give you a written opinion on it before the June meeting.
Okay, thank you.
Ms. Watts?
Thank you. Don't sit down.
It's part of my aerobic exercise.
So, when you issue your legal opinion and such, make sure to include, my guess is, being a non-lawyer, is that this action is not mutually exclusive of also repealing it. I think because of the historical significance that it deserves all of the above. And so please address that.
I will address all
Thank you, Madam
avenues.
Speaker.
The other comments?
Just one more. I think you all missed the point I've been trying to make. I'm not against correcting the record. What I'm against doing is correcting it by this method. I suspect that this method has some constitutional defects. There are other ways to go to correct the record and accomplish what you want to do other than this method, and that are a much more common method that would be used would be to repeal. And that's what I have a problem with, is bringing in some convoluted method by which to correct the record. I just think that we could do it a lot cleaner And I want to make that point, that that's the problem I have with this, and that's why I'm voting against it, is I believe we're getting into a constitutional defect. So we're compounding one illegal act by another possible illegal act. Thank you.
Ms. Knight, did you have a comment?
I did, Madam Speaker, and it goes to the issue of acts being found unconstitutional sometime after they're passed. These two enactments, in my layman's opinion, of course, are different, and they're different because they were not legitimate enactments from the beginning. They were not legitimate enactments because the group that purportedly enacted them were not acting on behalf of the council. You didn't have a body of the council that passed these acts. And so to repeal, to me, implies, from a layman's term again, and I hope that Mr. Hembry addresses this from a legal perspective, that those acts were legitimate until the point that you repealed them. And it is my belief that they were not. So thank you.
Thank you. One more question, then we'll call for the question. Ms. Calmar?
You can call for the question, because I just want to make sure Secretary Knight was acknowledged. I was going to give her my time.
This is an act, so we'll have roll call. Yes, you agreed to the motion to approve.
Right here.
Carly Bezer,
Yes.
Julia Coates,
Yes.
Bradley Cobb,
Yes.
Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Fraley,
Yes.
Janelle Fulbright,
Yes.
Don Garvin,
Yes.
Chuck Hoskin Jr.,
No.
Tina Gloria Jordan,
No.
Chris Soap,
Yes.
Curtis Snell, David Thornton,
Yes.
Kara Cowan Watts,
Yes.
Bill England,
Yes.
Bill John Baker,
No.
Jack Baker.
Yes.
Be 11 yes and 5 no.
11 yes, 5 no, motion carries.
Madam Speaker,
Yes.
if I may amend on time-sensitive number 5 here on new business. I've just actually got it in my hand, and I'll pass it down.
What is it?
It's just a clearance writing
I
form.
have a motion to amend the agenda.
Yes.
And a second.
Yeah.
Any discussion? We have about 10 minutes, Dr. Cobb.
It's, Chuck, I know we don't have video on you,
Motion
but,
to approve, all in favor, signify.
sorry, my fault.
What is it?
All in favor, signify by saying aye.
Aye.
All opposed, same sign.
Aye, because I don't know what it is.
It's just,
He's made a motion to amend the agenda.
For
include
For what?
an item, to include this resolution.
South Coffeyville Mobile Home.
He said he just got it,
I'm going to vote no still.
and it's dispose of a mobile home, so that shouldn't take long.
am I up or,
As soon as everyone gets one.
okay, am I?
Yeah.
Am I up? This is, the Cherokee Nation owns property in South Coffeyville, and this is just a time-sensitive, we got it from Pat Gwynn's group. There's a company, N&S Movers, that is owned by a Cherokee citizen. This grants them permission and authority to remove this mobile home from the property, and it is time-sensitive, and I just got it, so. And I know we don't have video with Chuck, I know he's on audio, he may have something to add, I don't know, but
You want to
that's.
make a motion?
I do want to make a motion to approve it.
Have a second, have a second, now discussion. Chuck, did you want to add to this?
No, I just, it's a wonderful opportunity to use a local Cherokee-owned business to remove a trailer that will really help out our Cherokee Community Organization in South Coxville, so I would just urge its approval. Thank you, Madam Speaker.
Thank you. Any other discussion? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries.
I was in the debate for a minute, been a while.
Are there any announcements? Yeah, entertain a motion to adjourn.
Second.
All in favor? Yes.
I have two announcements.
Just a moment, we have an announcement.
One, it's good to have Janelle with us today. She had health problems and made a great effort to be here. And another thing, I want to tell you about Todd Embry. I think he's one of the greatest attorneys around, but the main thing I want to say is his daughter won the state championship in the 1,600 meters, also 3,200 meters.
Good Cherokee citizen, Justin.
Okay.
It is good to see you.
We are, all in favor of adjourned? Aye. Adjourned.
He looks like Jack Lord from Wi-Fi.